Maybe, pardon my lord, I made a mention yesterday, but getting that
That is
NCLT
posted
matter.
tomorrow.
Tomorrow, my lord, it will be late because today, if the
No, we cannot. We will special bench constituted
special
as
bench,
per
if
the.
lordship can, lordship for 5 minutes, lordship can
No.
constitute bench at 2 o'clock, my lord, only before that data.
This is,
But tomorrow, my lord, it may become infectious.
we'll see that tomorrow. I have already asked him to list the matter tomorrow.
No, sir. I may be this admission matter. No, sir, I may be pardon, no, exceptionally urgent matter. A tender was revoked on the 13th of October. Revoked means it was totally cancelled. I was a participant. On 14th of October, they opened the financial bids of a revoked tender, and that too on a selected basis on some.
Why are you mentioning matter?
Lords, there's a noting that exceptionally urgent matters will be mentioned before Lordship, Lords.
No. Honorable Chief Justice matter will be taken up before us today.
No, not exceptionally urgent matters assigned to the court of the Honorable Chief Justice will be mentioned before your Lordship.
Where is that, please?
There's a noting, Lords.
I don't think it is because the J1 is there.
Towards the end of the
I didn't notice.
notice, Lords. That is why I'm being Lord. This is the
No,
first.
just let us check.
I'm sorry.
Second. Acha. Already give it.
Lords, I'm just praying that it will become infectious because they opened the
No, it will come tomorrow. Please give it.
tomorrow.
My lord, my lord,
Grateful, Lords.
assigned to Honorable Chief Justice Court, my lord. Yesterday, I had mentioned before your lordship. My lord,
Please give it. It will all. If you have given the memo, don't give. I have already stated that it will be listed tomorrow. Please don't give another memo.
my lord, demolition matter. Tell me, memo, they name, my lord. Demolition of house.
As petition retired since 2014. Pension matter.
Please give it.
Madam, to make a mention to various purpose matter. Assigned to
Give it tomorrow. It will come.
My mention will also come tomorrow, Lord.
I don't to mention one CRLA accused in custody more than 10 years.
Please give.
Next week, my lord.
Okay, please.
Supplemental list, item number 1. Next week, ma'am.
Please have patience. This has been listed for a particular purpose. So. Is staying in native from the here is the report dated 18/8/2025 of the inspector in charge of Porjang Police Station, Tenkana, produced by the Land Council for the state, which shows that the appellant is alive. Hello? That will be added to the hearing list.
Next week. Next week.
You have received the paper book. What is your good name? ଆପଣଙ୍କର ନାଁ କଣ? Dhal. Dhal, Land Council for the appellant submits that she has not yet received the paper book. Let the copy of the paper book, let a paper book be supplied to the Land Council for the appellant. That will be added to the hearing list next week. Hello? आज नहीं जातु आपनकर पेपर बुक है आसंदा सप्ताह लिस्ट आसिले कहबेनी जे हम पेपर बुक रिसीव करनु बोली 2004 मैटर 21 वर्ष हो गलानी यस नेक्स्ट
Item 2.
पेपर लिस्ट अछि कि ना नाही एटा एटा बोटी एडा सब एते केस कोन दे पाइ
तद्रे आया
34 दियंतु बिंग बुक
अल्ली फिर बता अल्ली
एटारला criminal appeal 34 appellant single appellant on asla
Elevation and staying.
alive
staying and
এটা alive actually that's the number ta council court Naik
Your Lordship, I'm appearing on behalf of Mr. Naik.
you have received the paper book
No, Your Lordships, I haven't.
what is your good name
Chetna Prakash.
Chetna Prakash land council appearing for Sudharanidhar Naik senior advocate submits you have not received the paper same order kar do next week it will be added to the hearing list right
Yes, Your Lordship.
so receive the paper book and get prepared yes.
Yes, Your Lordship.
Next
Item 3.
item see there are two appellants
out of one person has died.
who is ठीक है because they should stand as not inquiry revealed that Narendra Kumar Samal
Has expired.
has expired. Health
Yes,
problem.
that-
Certain- He Samal is alive. Narendra Hala appellant number 2. Appellant number 2 का date अच्छी. Appeal update so far as appellant number 2 is concerned. Appellant number 1 is with the council.
Taken.
Mr. P.K. Naik, R.R. Mahapatra. जानी जाएगी तीन नंबर टा देखो
Yes, yes, right.
जितने काउंसिल होते हैं देखिए
No disobeying.
हाँ ब्रह्मांड खंडन करा थिला आगुरु तापरे नो ऑब्जेक्शन आनी की फाइल कर चंदी पी महांती एमके दास इनफैक्ट तीन जनों का एडवोकेट गुड़ा इतने जनों का ना कौन पेज
Taken like 3 months and then.
जानी चंदी नंबर नंबर से तो ना तो 2007 में से भी जाना था मन भी असमान जो वन मने टिके सीनियर रही थी निश्चय टिके नायक ना 3-4 एडवोकेट हुए ते बाहर रे आपन को 1-2 मेंटेन हो टेलीफोन डायरेक्टली करे देले देखिले
प्रशांत नायक जन अछुन से बोधे प्रशांत नायक से हम सामने से वन
टिके नायक 1 का को लेता होगी
थोड़े आउटे भी टिके नायक
हां ता भीतर पी महांती और इनके दासेटा लिखि दियंतु अच्छा नॉन अपीयर्स लिख दियंतु फॉर द एफएलएंड the names of PK Naik -1 P Mahanti and MK Das shall only be reflected in the cause list henceforth. है बाकी land council for the हम लेके आपको ये करी था जाने ही दे बोली land council for the state submit that we will ascertain the will intimate the land council for the appellant about the listing of the case. It and you one mortgage organized. What a bit color. Yes, sir. Next week of the include for the hearing list. 4 number then. Single appellant. Your products out. নম্বর দেখিন দিও criminal appeal bound চক্রধারী সাউ staying in the village alive আচ্ছা জ্যোতির্ময় সাহু ওকালত নম্বর পাইছি জ্যোতির্ময় সাহু PS দাস
জ্যোতির সাহু को कम्युनिकेट कर दो
वो इंटीमेट कर देवे ना दिवे এটা লাইভ আছে নি हाँ जी ये आगुरु थिले बोधे कटि जाइछन्ति ई पंडा
কালকে জল করা হচ্ছে
জ্যোতির্ময় সাহু
তিনজন করা হচ্ছে সংস্কৃত তিনজন করা হচ্ছে নাটা জন করা হচ্ছে সংস্কৃত তিনজন করা হচ্ছে
হ্যাঁ
নাটা জন করা হচ্ছে
জ্যোতির্ময় আমাদের PS দাস তাই
এটি কিন্তু কিছু নেই
এটা তো তবে না PS দাস
বকলার নাম জ্যোতির্ময় সাহু
হ্যাঁ
and PS that
তিনজন আছেন জ্যোতির্ময় সাহু PS দাস মানে আজ যে এই যে এমানে দেবাশিস পଣ୍ଡାଙ୍କର ହରିଆ ନା ଚାମ୍ବରରେ କଣ ଏଟା ଟ୍ରାନ୍ସଫର ହେଇଛି ନା କଣ ତାଙ୍କ ନାଁ କାହିଁକି ଆସିଛି ଡି ପଣ୍ଡା ଆଣ୍ଡ ଡିପିଆର ଫଳ ମାନେ କଣ
କେତେବେଳେ ଥିଲା
କେତେ ନାହିଁ
ମୋଟେ ଆରମ୍ଭ କରିଥିଲେ
ହଁ ଏଇଟା ଫାଇଲ ହେଇଛି 2000
ଯେ 4 ର
ହଁ 4ରେ ଏଇଟା ଫାଇଲ ହେଇଛି ଇନିସିଆଲ ଓକାଲତ ନାମଟା ହୋଇଛି 27/2004 ତାପରେ ଦେବାଶିଷ ପଣ୍ଡାଙ୍କର नो ऑब्जेक्शन ବୋଧେ ନେଇକି ଫାଇଲ ହେଇଛନ୍ତି ପଡଲା ହେ ଓକାଲତ ନାମଟା
ମେସେଜ এটা ହେଲା 23/11/2000
ना I have no objection ଲେଖା ହେଇଛି So ଦେବାଶିଷ ପଣ୍ଡା DPR ହଳ GR ମହାନ୍ତି AK ପରିଡ଼ା ଆଉ B ତରାଇ ଚକ୍ରବର୍ଷ brief transfer ହେଇଛି
I have no objection
ହଁ
on that.
so it is your client office brief तो ये ज्योतिर्मय साहू ଆଉ कौन PS दासଙ୍କର ଥିଲା ପ୍ରଥମେ ତାପରେ କନସେଣ୍ଟ ଆଣିକି I have no objection ଲେଖି ଦେଇଛନ୍ତି ତାପରେ ଆପଣଙ୍କର ଏଟା ଲାଟେଷ୍ଟ ଅଛି
14/12/2004
have you seen that वकालत ना page number 72 so you collect the paper book and since if Mr. Devasis Panda and his associates have entered appearance for the appellant after obtaining no objection from the earlier engaged counsel, Mr. J. Jyotirmoy Sahu. The name of Mr. Jyotirmoy Sahu and PS Das shall not be reflected in the cause list. So also appearing for Mr. Devasis Panda submits that she may be supplied copy of the paper book. A copy of the paper will be supplied and matter will be listed next week. अच्छा तो report आसला पर live अच्छी ना इला ऊपर रहते हैं हाँ so it will come next week and you collect the paper book just now हाँ 5 number person what would you 69/2004 single appellant Uma Shankar Parida counsel ଆପଣଙ୍କ ଚାମ୍ବର ରାମାନନ୍ଦ ପଣ୍ଡା and associates
different after getting different
Which have been tagged together.
ହଁ ନାଇଁ ନାଇଁ ଠିକ ଅଛି এটা alive ଅଛି first item ଟା CRLA 69 of 2004 ଉମା ସମ୍ପର୍କ ଏଟା alive ଅଛି ଆଉ paper book କାମ ଦେଇଦେବେ ଆୟୁଷ ମେଟା appear for ଦେବାଶିଷ ପଣ୍ଡାଙ୍କର ବ୍ରହ୍ମାନନ୍ଦନ ପଣ୍ଡାଙ୍କ ନାଁଟା ଡିଲିଟ କରିଦେବେ ହେଲା ବାକି ଆଉ ସବୁ ନାଁ ରହିବ ନେକ୍ସଟ ୱିକ୍ ଆସିବ ତାପରଟା ଦିଅନ୍ତୁ ସୁଶାନ୍ତ ପରିଡ଼ା ଫାଇଲ ଆଉଟ୍
73-4
ସିଙ୍ଗଲ ଆପଲାଣ୍ଟ କଣ କୁହନ୍ତୁ whereabouts report well-being
Saying apple in his village.
ଦିଅନ୍ତୁ କପିଟେ ଦିଅନ୍ତୁ ଆପଣ ଅଫିସ ଆପଣ ଗୋଟେ କପି ରଖନ୍ତୁ ଆଉ ଦିଟା କପି ଦିଅନ୍ତୁ ହେଲା ଇଏ ଆପଣଙ୍କ you are associate of Ramanikaant Patnaik. So you receive the paper book. No, you receive today and ask your senior to get ready. It will be listed next week. Hello? And you give your name so that we are recording the name. The Land Council for the state has produced also indicate that the appellant Sushant Faridas, the appellant is alive. The report is taken on record. Hello? Who also appearing for Mr. Ramanikant Patnaik. The means they not receive the paper book. Hello? Get the copy of the paper book. Right? Next week, for hearing. After next, Ranjan Kumar Parida, Mr. Saurachandra Mahapatra. Single appellant. ପଦ୍ମନାଭ ଏଟା ପୁରା ରଞ୍ଜନ କୁମାର ପରିଡ଼ା
ପୁରା ଅଛି ସେ ପର୍ଯ୍ୟନ୍ତ ଥାନାର ସେ ଦେଇ ଦେଇଛନ୍ତି କୋଉ
କାଇଁ ତା ନାଁଟା ନା କାଇଁ
ରଞ୍ଜନ ପରିଡ଼ା ନାଁ ତ
ଆଉ ଗୋଟେ କୋଉଟେ ଦେଇଥିଲେ କି ଏଟା ଦେଇଦିଅନ୍ତୁ
ଆଉ ଗୋଟେ ଥିବ।
ଆଉ ଗୋଟେ କଣ ଏଟା ହଉଛି କ୍ରିମିନାଲ ଅପିଲ 91/2004 ସିଙ୍ଗଲ ଆପେଲାଣ୍ଟ ନାଁ ହଉଛି ରଞ୍ଜନ କୁମାର ପରିଡ଼ା
ଭୁଲ
ଏଟା ଦେଇଦିଅନ୍ତୁ ଦିଅନ୍ତୁ
ନାଇଁ 5
କଣ ମାନେ ସୁଶାନ୍ତ ପରିଡ଼ା ଆଇଟମ
ନାଇଁ
I'm repeating to tell you. Criminal appeal number ଆଉ ଇଏ ଚେକ୍ କରିକି ଦବାକୁ ଏତିକି ଚେକ୍ କରି ଦେଇ ପାରୁନାହାନ୍ତି
Item 5, sub item.
आइटम 5 रो आपण उमाशंकर परिडा देले लेखा है ठीक अछि तापर सेकंड आइटम टा होची सीआरएल 73 ऑफ 2004 सिंगल अपेलेंट ना होची सुशांत परिडा
That is not.
हाँ?
91, 92 data file. Much more for there is 73 by their charge that file report has not.
ଆସିନି
से कहूना थी भूल नोटिंग ही होची ना सेटा 73 नु सेटा ठीक है सेटा तो दियो ऑर्डर डका जाओ 73 ऑफ 2004 सुशांत परिडा रा आपण रिपोर्ट पाइना
Input हम हो गया
73 ऑफ 2004
ना
जोटा आइटम नंबर 5 रे अछि ता ना होची सुशांत परिडा तार रिपोर्ट पाइना थी
क्या आसिन तो that's why
फाइल मगांतु फाइल मगांतु आपनकर ये को इंस्ट्रक्शन दियंतु इमीडिएटली नै कि नासियो
night one night two also same.
तापर व्हाट अबाउट दिस क्रिमिनल अपील 91 ऑफ 2004
That is file for the day 91 and 92.
91 ऑफ
90 yes 92.
92
Right.
फाइल मगै छथि फाइल मगाइ छी असुरै करू ए तीनटा
ଚାରି ଜଣ
हां चार जन जे गोटे ऑर्डर हला और तीनटा से लगे छथि फाइल देखिलो कोडा पूरा फाइल नहीं और रिपोर्ट कोन आछो हां
Six.
74 वासुदेव रण सिंह सिंगल अपलेंट एटा तो अच्छी हो व्हाट अबाउट द काउंसिल मिस्टर धौल डीपी धौल
Lordship, paper.
हैव यू रिसीव्ड द पेपर बुक
No, your lordship.
रिसीव द पेपर बुक गेट रेडी नेक्स्ट वीक
Yes.
ना दियंतु अपन करो on behalf of Mr. DP Dhol senior advocate yes
Item 7.
And the 5 appellant.
ठीक है रोंदो there are 3 appellants
3 of 3. 1, 2, 3.
Padmanabh Sahu Avagrahi Sahu Kumar Sahu
Who has that?
Who has dead? Padmanabha ji working as a sub.
रिपोर्ट दियंतु हमें रिपोर्ट दियंतु क्रिमिनल अपील वेरीफाई करिंग दियंतु
2, 3, 4.
क्रिमिनल अपील फास्टा होची 100 of 2004 ର ପଦ୍ମନାଭ ସାହୁଧାରଲା appellant number 1 ହେଲା ତାପରେ ଭାବ ରାୟ ସାହୁ ଗାଇଡ ତାପରେ होची କୁମାର ସାହୁ ହେଲା ଲେଖି ଦିଅନ୍ତୁ there is the reports one so ଗୋଟେ ମରିଛି appellant number 2 ଟା ଆଉ ଅନ୍ୟ ଦିଟା ଇଏ ଅଛନ୍ତି ଏଟା update କରିଯିବ ବାକି କାଉନସିଲ ନା Mr. Ramesh Chandra Behra and council is present you have received the paper
No.
paper will be supplied
No.
next week
One week after that. I will not be.
come next week it may not reach but we are not giving long adjournment
27, 28 I will not be.
हमें अपन को adjust करी but we are passing the uniform order so that yes
Item 8.
single appellant
Presently earning his life.
हाँ
Presently earning his life.
अच्छी तो सारी की जा रही है कोटे को बाकी जुड़ी रही वाला और बहुत ठीक कर ले देखो हम पंचायत जा कोई भी इसी वाले से मन criminal appeal number or na it is verified এটা হলো 101 of 2004 appellant
Like,
as desired in connection to one, so presently the appellant is earning a alive name. Yes, the learning council, you are there?
My,
For Mr. SK Party?
my,
All right. Give your, and you collect the paper book, it will be listed next week for hearing. Okay. Give your name. Next.
Item 9.
Date. Date. June. Single appellant. Radhu. That's yeah. Died since 15 years back. Wow. Date abates disclosed document. এগুলো আমরা লিখে দিতে আমরা নর্মালি লোকেশ ট্রেডিং এর করি কিন্তু ওই ফরম্যাটে ঢুকে দেয় item 10
Item 10.
single appellant
ছজন
নাই তো ছজন
ছজন আছে
all are alive. Okay.
অচ্যুত আপনাদের নরোত্তম
অরুণ বড়ার 1,
দুই।
অচ্যুত 4, নরোত্তম 2, সারঙ্গধর বড়ার 3, কল্লার আলাই
চারি
নরোত্তম
ଆଉ ଦିଟା ଚାରି ଜଣ ଦେଇଛନ୍ତି 6 ଜଣ ଆପଣ ଆପଣ ଦେଇଛନ୍ତି ଅରୁଣ ବରାଳ ମାନେ
1,
A1
A1,
ତାପରେ ହେଲା ଅଚ୍ୟୁତ ବରାଳ ହେଲା
ଅଚ୍ୟୁତ ବେଲା 4,
A4
নরোত্তম A2,
ନରୋତ୍ତମ ହେଲା
A2,
A2
A2,
ତାପରେ ହେଲା ଆଉ ଗୋଟେ ଦେଇଛନ୍ତି ସାରଙ୍ଗଧର ମାନେ A3
5 and 6 are not provided.
so what about
5 and 6
A5 ଆଉ A6 ର ନାହିଁ
ନାଇଁ fully obtain that.
ଆଣନ୍ତୁ ସେଟା ଲେଖନ୍ତୁ the learned counsel for the state has produced the report dated so and so IAC Begonias police station which shows that A1 so A2 so A3 and A4 are alive but there is no information in the said letter about appellant number 5 Purna Varala and appellant number 6 Raja alias Rajkishore Varala. So their houses comes under the same Begunia police station. Land council for the state seeks some more time to obtain instruction regarding the well-being of appellant number 5 and
6.
notice of foreign
for informant we are there. For informant we are there.
the land council also appears for the informant. Who is for the appellant?
If
Mr. Mahanti,
Again.
Gopal Krishna
Gopal.
Mahanti,
Krishna Mahan. I will
intimate him. And he has to collect the paper book.
Again.
We are mentioning that non-appears for the appellants. Non-appears for the appellants.
Also, it may be a take soft copy.
You are for?
Informative.
Soft copy.
The paper. You have a right, you can get the paper book copy, there is no problem. What is your good name?
They will actually refer a lot. On behalf of Mr. Pandey.
No, no, ठीक है, give it in writing. So and so, appearing for D. Pandal and counsel for informant, submit that he has not received the paper book. Let a copy of the paper book be supplied to the land counsel for the informant. ଏଠି ଅପେକ୍ଷା କରନ୍ତୁ ନେଇଯିବେ ହଁ ଯେଉଁମାନେ ପେପର ବୁକ୍ ଦେବେ ତାର ଅର୍ଡର ସିଟ୍ରେ ସିଗ୍ନେଚର ନେବେ ହଁ ଆଉ କାହା ପାଇଁ ନଉଛନ୍ତି କାରଣ ଆସୋସିଏଟ୍ସ ମାନେ ନଉଛନ୍ତି ଫର ଲେଖିବେ ଫର ଦେବାଶିଷ ପଣ୍ଡା କି ଫର ଡିପି ଧଳ ହେଲା Mr. Mahanti, please intimate Mr. Gopal Krishna Mahanti, huh? Yes, next item.
Item 11.
He's alive.
For the alias Pradeep Sahoo.
He's alive.
Alive.
Working in a Habat on good.
Huh?
Working in a Habat on
No,
good.
she put alive. What about the council?
Yes.
Sarveshwar Behera.
The state panel.
State panel ligran. Baki PR Singh और SL Chaudhary.
Associate of Mr. Service.
कौन राजा लिखिदेवी जणेदेवे बोली PR सिंह को जणेबे अच्छा it is stated that Mr. Sarveshwar Behera सेटा लिखित value is now in state panel. The name of Mr. Behera shall not be reflected in the cause list henceforth. None appears for the appellant. Counsel for the state submit that he will intimate Mr. PR Singh about the listing of the case and to receive the copy of the paper put up this matter next week. Yes, next.
Pardon me. Under item number 10, my lord, I got for that the time of call, my lord. My lord, on behalf of Mr. J.K. Mahant, may allowed to take up to 2 weeks, my lord.
No, we do it. Item number 10, your client is alive. That instruction we have taken.
Only
And 2 of the appellants are information are required to be taken further. And we have listing this matter a week after. In the meantime, you collect the paper book. Are you having the power in this case?
My lord, we have filed a fresh वकालतनामा, my lord.
ଆପଣ fresh वकालतनामा ଦିଅନ୍ତୁ ଗୋପାଳ କୃଷ୍ଣ ମହାନ୍ତିଙ୍କର ନାଁ ଅଛି
My lord.
ତେଣୁ ଯଦି ଆଉ ଫ୍ରେଶ वकालतनामा ଦେବେ ଦିଅନ୍ତୁ ପେପର ବୁକ୍ କପି ରିସିଭ କରନ୍ତୁ ପ୍ରିପେୟାର ହେଇଯାଆନ୍ତୁ ଗୋଟେ ସପ୍ତାହ ପରେ ଏଟା ହିୟରିଂ ରେ ଆସିବ ହେଲା ଠିକ ଅଛି ନେକ୍ସଟ ନନ୍ ଆପିୟର୍ସ ଟା କାଟି ଦିଅନ୍ତୁ ଆପଣ ନାଁଟା ଦିଅନ୍ତୁ wants to appears for Mr. Gopal Krishna Mahanti. 12 number ଟା କଣ
I thought 5 connected up to him. No, all are addicts.
ଦିଅନ୍ତୁ ସବୁ ବୋର୍ଡ ଆଗରେ ମିଷ୍ଟର ଡିପି ଦଳ ଅଛନ୍ତି ତ
Your Lordship, Narayan Chandra Sankhwa, Senior Counsel D. Nayak is there. Your Lordship, CRLA 136 of 2004, Narayan Chandra Sankhwa. For that one, Senior Counsel D. Nayak is there.
କଣ ହେଲା କଣ ଆପଣ କହୁଛନ୍ତି
Your Lordship, we are appearing for that particular matter.
Have you filed the Binama? Have you filed the Binama?
Power is
There.
yes, sir.
That's all right. ଲେଖନ୍ତୁ ପ୍ରଥମଟା ଆଇଟମ ଦିଅନ୍ତୁ 116 ଗୋଟେକରେ ସମସ୍ତଙ୍କର ଅଛି ନା ଅଲଗା ଅଲଗା କରି
ଅଲଗା ସିରିୟଲି କରିଦେବି
ହଁ ଦିଅନ୍ତୁ
ସିରିୟଲି କରିଦେବି
ଏଠାର CRLA 116 ଲକ୍ଷ୍ମୀଧର
ଲକ୍ଷ୍ମୀଧର ପାତ୍ର
ପାତ୍ର ଆଚ୍ଛା ଆଲାଇଭ୍ ଅଛନ୍ତି ନିଅନ୍ତୁ ଆଉ ଡିପି ଧଳଙ୍କର ଆସୋସିଏଟ୍ ଅଛନ୍ତି ପେପର ବୁକ୍ ଗୋଟେ ପେପର ବୁକ୍ ଦେଇଦେଲେ ହେଇଯିବ ତାଙ୍କ ହେଲା ସବୁ ଗୋଟେ ଆଇଟମରେ ଲେଖିଦେବ ତାଙ୍କର ଗୋଟେ ଏଇଟା ହଉଛି ଦ୍ୱିତୀୟ ନମ୍ବରଟା ହଉଛି 118 in respect of ଦୋଳ ଗୋବିନ୍ଦ ସିଙ୍ଗିଲ ଆପେଲାଣ୍ଟ
ସିଙ୍ଗିଲ ଆପଣ
inquired ଗୋବିନ୍ଦ is alive ଅଚ୍ଛା ଦୁଇ ତାପରେ 3 ନମ୍ବରଟା ହଉଛି connected
ମୁରଲି ଜେନ 121
room
ଜଣେ
single Muralidhar alive being alive then 426 Bonno alias Sarat Chandra Behra
alive
alive ତାପରେ 5 52 alias Saroज Kumar
ଶରତ କୁମାର ସାତ ଇଏ alive
128 2004 Saroज Kumar Patra is alive still ତାପରେ ନାରାୟଣ ଚନ୍ଦ୍ର ଶଙ୍କୁଆ ନାରାୟଣ ଚନ୍ଦ୍ର ଶଙ୍କୁଆ କାହିଁ ତାଙ୍କ ମ୍ୟାଡମଙ୍କର ନାରାୟଣ appearing for the
ଏଟା ସିଆରଲି 136 ଏଟା 3 appearance
in 136
ଆଚ୍ଛା ଇଏ
ନାରାୟଣ ଚନ୍ଦ୍ର ଶଙ୍କୁଆ
2-3 କଣ ଏମିତି ଗୋଲ ବୁଲା ହେଇଯାଇଛି ମରିଯାଇଛନ୍ତି କି ଆଉ ନା
ନାରାୟଣ ଚନ୍ଦ୍ର ଶଙ୍କୁଆ ବୁଲି ଆଲିଆସ କମଳାକାନ୍ତ ଟିକିଲି ଆଲିଆସ ସୀତାକାନ୍ତ
no that is all India ଗୋଟେ ରାଉଣ୍ଡ କରାହେଇଛି
Round କରାହେଇଛି।
2 and 3 କଟ କଟା ହେଇଛି
ସରୋଜ କୁମାର ନା ନାରାୟଣ ଶଙ୍କୁଆ
ସେମାନଙ୍କୁ ବେଲ୍ ହେଇଯାଇଛି ବଟ୍ ଗୋଟେ ଗୋଲ ବୁଲା ହେଇଛି ଫାଇଲରେ କଣ ପାଇଁ ବେଲ୍ ଦେଲା ବେଳେ ଗୋଲ ବୁଲା ହେଇଗଲା
ନାରାୟଣ ଦେଲା
ନାଇଁ ନାରାୟଣ
କେବଳ ଜଣକର ଦେଇଛନ୍ତି ରିପୋର୍ଟ
ହଁ ନାଇଁ ନାଇଁ 2-3ଟା
ଦିଆ ହେଇନି
ବୁଲୁ କମଳାକାନ୍ତ ଟିକିଲି
but you received that report in respect of appellant number 2 and 3 they have been granted bail also ଲେଖନ୍ତୁ ଏଇଟା ହଉଛି ଯୋଉ ଲାଷ୍ଟ number 136 of 2004
earlier there was a report sir because Kamalakanta is earning his livelihood by selling
The report read appellant number 1 is alive and counsel for the state however submits that the appellant number 2 and 3 have been granted bail and may be given some time to obtain the well-being report of 2 and 3. Matter listed on so and so, she is present. You collect the paper book, okay? ଗୋଟେ ଡେଟ୍ ଆସିବ ସବୁ ଦବ କାରଣ ଏର ୱିକ୍ ହେଇକିନା ଅଛି
Item 13.
paper book maybe hard questions. Lakshman Kumar Saw. Criminal appeal
Soul.
check करिवे appellant ना check करिवे तब पढ़ेवे ये गुड़ा का टिके sketch मार दियो criminal appeal number और ना एती कर आउट कर और alive की date से टिके मार दियो criminal appeal लक्ष्मण सर नाटर मो पहला सुबिलानी नाटर मारिबो येटा मारिबो वाला अलाइव तीनटा मार दे अच्छा एटा पंची की अछंती काउंसिल योर व्हाट इज योर गुड नेम
प्रताप कुमार बेहरा
you have no power in this case
no matter on behalf Mr. Naik
you are on mentioning on whose behalf
Mr. SK Naik
SK Naik senior counsel
And you receive the paper book and get ready for hearing. It will come next week. Anyway, the allowed report. ଏଗୁଡାକ ସବୁ ଆସିବ ଠିକରେ ଗୋଟେ ଦିନରେ ସବୁ ପଡିଯିବନି ତେଣୁ you get ready then. Yes, next.
Item 14.
$348/2014 कौन है रिपोर्ट कहीं मगाइनी लिखा है कॉज टाइटल prisoners petition for illegal चल रहा नहीं वंचित हो गया केबे का 2013
ରିଜୁଆରାମ
बुद्धूराम आउट होची रिजूराम भी से कनेक्टेड मैटर बट पेपर बुक नहीं जैसे देवस्नान दास को गले
May I please, Lordship? I'm appearing on behalf of Mr. Devasnan Das, Your Lordship.
the client is writing letter for early hearing.
Lordship, in the meantime, he has been released on bail, Lordship, on 11/4/2025, Your Lordship.
तो कौन है
Buddha Oram, Your Lordship.
कि लेकिन तो ड्यू कोर्स আছে 2014 में तो पुराना मैटर আছে देखो one so what is your good name ma'am?
Adya Shakti Priya, Your Lordship.
Adya Shakti Priya, land counsel appearing for Mr. Devasnan Das submits that the appellant, it has the first item, CRLA number 348 of 2014. Submit that the appellant has been directed to be released on bail by the order dated 11/4/2025. So, though the prisoner's petition has been filed for early hearing, but the paper book has not been prepared. Let the paper book be prepared in due course and the matter is listed for hearing thereafter with CRLA number 347 of 2014. Next.
Obliged, Your Lordship.
Item 15.
Take instruction regarding further order of this.
In this case, my lord, the order as the representation has not been disposed of. That is my instruction, my lord. However, my lord, today, in the course of the day itself, my lord, the speaking order is going to be passed. The order has been made ready, my lord. It is only to be signed by the chief secretary. My lord, we only call the matter on Monday or tomorrow also, if my lord speaks.
No, not tomorrow. It will come next week.
My lord.
We just want that
My
it will be disposed.
my lord, will be done before the next.
The learned additional government advocate. Even Mr.
Sanjay Rath.
Sanjay Rath submits that he has obtained instruction that the representation of the petitioner is likely to be disposed of during the course of this week, and the matter may be taken up next week to apprise this court about the latest development. Put up this matter on, we are listing it on 30th,
My lord,
next
Thursday.
30th October 20.
Item 16.
Item 16, may I please, Your Lordship? Your Lordship, I'm alleging the non-compliance of the order dated 5/9/2024, Your Lordship. On the last occasion, time was granted to the NHI authorities, Your Lordship, to take instruction, Your Lordship, regarding compliance.
Who is appearing for Mr. Amitabh Das? Mr. Das is here. Yes, Mr. Das?
Yes, well, it will be complied within period of 6 weeks, well, ideal time. Let's we give time because we have written for placement of funds.
Same matter, we cannot extend. You are to come up with your application. You have not come up with the application.
Today, in course of the day, we will file the compliance affidavit, my lord. That will comply because we have already written letter for placement of funds. Because funds will be released by central government and it will be credited to the accounts of the NHAI and thereafter it will be released.
The order dated 5/9/2024, we have quoted the operative part of the order in our order dated 12/2025.
Yes, my lord.
It reads that in view of the letter of the collector Burger,
Yes.
the valuation report furnished by the executive engineer R&P Burger, and after hearing the learning counsel for this one, so we direct the NHI authorities to take immediate steps for payment of compensation to the petitioner as per the valuation report within a period of 1 month from the
Yes.
date of production of the certified copy of the orders.
Yes, my lord.
Before
Yeah.
taking any steps for vacating the premises. And the NHI authorities shall also communicate the order to the concerned authorities for compliance. So
Yes, ma'am.
that order was passed on 9/2024, and he has produced the certified copy of the order before you, and the date has already expired since long. And
No,
it
my lord,
was-
thereafter review was filed.
Yes,
Thereafter review was filed.
yeah,
Well, review was dismissed on 16/9,
69,
2025.
2025.
Yes, ma'am.
Where is that?
My
You are
lord,
not mentioning anything. You have appeared also 16/9/25. The matter was listed also before us in the
Yes, ma'am.
contempt application.
A review was filed against the order dated 5/9/2024, my lord. A review was filed by the NHAI. Review number 293/2024. And that review was dismissed on 16/9/2025, my lord.
Mr. Amitabh Das, Land and Senior Advocate, appearing for the contender opposite party, submits that a review petition was filed by the contender opposite party, against the order dated 5/9/2024, passed in WPC number Charita 2/8 of the Results Office.
Yes.
However, the review petition was dismissed on
16/9/2025.
16/9/2025. So now the chapter is closed. So
Yes, ma'am.
you have to comply the order.
My lord, here we have already written, my lord, to the authority for placement of funds.
No, whatever you give it in writing so that
Yes, ma'am. In course of the day, I will file, ma'am.
the land council submits that he will file a written inspection during course of the day about the compliance of the order regarding steps taken for compliance of the order dated 5/9, aforesaid order dated 5/9/2024.
Yes.
Out of this matter, we are bringing it at next Thursday.
Yes,
So
ma'am.
you do the needful.
Yeah.
30th of this matter on 30th of October 2025. Yes.
Obliged, your lordship.
Item 17.
Mr. Alawala, General and Counsel for the petitioner, is present through virtual. Yes, item 17.
May I read some? On last petition, that one had after no instruction. It claims obtained instruction in the matter. Non-compliance with the order dated.
Look, sir, given the order, the speaking order has been passed, representations have been disposed of. I'm also giving a copy to the petitioner.
The land council for the state has produced the written instruction received from Smart Soul, which is dated 29/4/2025, showing that the representation of the petitioner has been disposed of. And the prayer of the petitioner for grant of rehabilitation assistance scheme as an extended family has been rejected, being the word of measure. Copy of the order has been handed over to the Land Council.
Let me say that lands, they have passed the order on that date.
File challenge it, file a separate content application ଆମେ କଣ କରିବୁ? So the accordingly the content application.
Item 18.
18.
My lord, in this case also, my lord,
Same order.
my lord.
Same order. No. जे जहाँ file जे जहाँ order रखियो देखिए नहीं. नले यार सर तळटा होची आइटम नंबर year 17 ना ता ऊपरटा होची आइटम 18 ना लिखी दिए खाली सीरियल नंबर टा लिख और चेक करिवो कंटेंट एप्लीकेशन नंबर और पिटिशन नंबर और ये appellant रो सॉरी पिटिशनर रो नाटा भी चेक करिवो एटा ड्रॉप होला 18 नंबर नेक्स्ट
Item 19.
Last occasion, directed to if not comply the order, personal approach may be found to the content.
Let's have not received any instructions.
get the instruction
Malad.
the representation file
Malad.
run counsel for the state 6 some more time to obtain instruction as per previous order stated 25/9/2025 and 14/10/2025. So we are listing it in November. I'll get that instruction. November 11 तारीख को are getting sufficient time. 11th of November 2025 है ना? Instruction regarding compliance.
11 personal difficulty, any other.
11?
My personal difficulty in 11.
हाँ केबे
Any other date.
अच्छा 13 तारीख अछंती?
Yeah.
13 तारीख 13/11/2025. All right, next.
Item 20.
The order has complied. Well, in this case, although I have received verbal instructions, Lord, that it has been complied, an order has been passed, but I have not
You have
received.
received the copy of the.
No.
No, Lord, sir.
Give the
Lord, short date, Lord.
next week.
Next week.
The land council for the state submits that those he has received the instruction over phone that the order of this court dated such and such, passed in such and such has been complied with, but the matter may be taken up next week to produce the compliance order. This matter. So, Guruvar din asu, 30 तारीख 30th of October 2025.
Item 21.
Maybe 30th. Next date, any other date. 30th.
You are not available.
No.
Comply ये खाली रानी produce करे आता है अपने account हो जाए. 6th for the 6th of
6th November.
6th for 2020.
Item 21.
Last occasion, your lordship giving last chance. Complaints, my lord.
In this case, Lord, I have received some instructions, Lord. My Lord may not be adequate, my Lord.
The instruction is not adequate.
My Lord, they have only paid for some more time.
And
My Lord, they have paid for some more time, my Lord. They are saying that funds have to be sanctioned from the government and they have written to the government. Some time is required. That is what the instruction says, my Lord.
the order in the operative portion we have quoted in order dated 21/8/2025 that we dispose of the writ petition with the direction to the opposite parties number 4 and 5. Tahsildar Land Acquisition Officer Gauri and Executive Engineer Jarka Irrigation Division Jarka to disburse the compensation amount as expeditiously as possible, preferably within a period of 2 months from the date of production of the certified copy. This order was passed on 24/9/2024 and the communication has been made twice to you.
My Lord.
Once on 48/2025 out there, 27/2025. So detail लिखा ही थी order dated 21/8/2025.
No.
In this case, my lord, land has acquired since last 13 years. In
And
2012.
the period has long since over.
Over, man.
24/9/2024 ରେ 2 ମାସ ଦିଆଯାଇଥିଲା from the date of production of the certified copy and certified copy was produced 20/2025 ଆଉ ଥରେ ମଧ୍ୟ 23/2025 କଣ ଶୁଣ?
Today, my lords, let me see the instructions. They say, my lord, that on the second page, my lords, may see. They say that, my lord, they are going to pay, my lord, but funds are not available. That is why they have.
That is your head up. You do not know. You
My
are
lord.
not seeking for extension of time. If
My
you are
lord.
facing this difficulty, at least a
My
interim
lord.
application should have been filed
My
in
lord,
the
I-
dispatch of that give us some more time. The fund. You are sitting idle, and now after this content petition is filed, you are coming up that we have no fund or the some more time is required.
My lord, we'll file. We have to file an application for extension of time. My lords may grant one opportunity.
No. We are just granting you another time, but whatever you want to do.
My lord.
Which line you have mentioned?
My lord, the second page, the second and third paragraphs.
Currently
Mochi
fund is
Dita
not
paragraph.
available.
My lord. Currently, and then the next paragraph.
Move to so and so. It will take 1 month time as discussed on also the order. So this letter dated କେବେ ଗଲା? 23/10/2025. So ଆପଣ ଗୋଟେ ମାସ କରିଛନ୍ତି ପରା?
ମାଗୁଛନ୍ତି।
ଲେଖନ୍ତୁ ଆପଣ the Mr. Ranjit Mahanti, Land Counsel for the petitioner is present. Land Counsel for the state has produced the written instruction dated 23/10/2025 received from Tahsildar Wari, which indicates that currently fund is not available in SC Jarka Irrigation Division, for which the SC has moved it to direct purchase process, and it has been approved by the collector Jajpur, and it will be sent to government for sanction, and 1 month time is required for this purpose. And it is further mentioned that once compensation amount is sanctioned, it will be disbursed as soon as possible to the petitioner. The report is taken on record. Matter will be listed on 27th November 2025. Okay.
Item 22.
Item 22, may I please your lordship? I'm alleging the non-compliance of the order dated 24/9/2024, your lordship. Yesterday, we received a show cause affidavit filed by the NHI authorities, your lordship, wherein they have stated that they require 8 weeks time to comply the order of this honorable court.
Sunil Kumar is not the general manager. He has filed show cause to delete his name.
ଆପଣ କଣ କାଲି ଗୋଟେ
ମୁଁ କାଲି ଦେଇଛି on behalf of the NHI, and because even though he is not
document is not on record. କଣ ସେଟା ସାଇଡ କରିଛନ୍ତି କଣ ଆମେ କହିବୁ ନା ରେକର୍ଡ ଫଟୋ
ରେକର୍ଡ ଅଛି
ଆପଣଙ୍କର ଅଛି ରେକର୍ଡ ଆସିବା ଦରକାର ନା। Report listened 8 weeks time.
Paragraph number 2.
Full line. Another 8 weeks time to file the compliance application. Mr. Mahanti, Land Counsel appearing for the NHI, submits that yesterday a show cause has been filed on behalf of the opposite party contemner, bracket NHI, in which it has been mentioned that another 8 weeks time is necessary to file the compliance affidavit. the learned counsel for the petitioner, Ms. Salvana Jana, appearing through virtual mode, submits that she has received the copy of the show-cause filed by the opposite party contender. The show-cause be placed on record. Matter be listed. We are listing it on the same day, that is on 27th November 2025. You tell us the development made in the meantime. Leave this matter on 27th November 2025. Mr. Mahanti shall apply this code about the development made in the meantime. Can agent of
settle same. Next is same.
next same.
Again.
So 8 weeks time mentioned.
Again.
Like সেটা भी কালি ফাইল করছেন
আগে।
গতকালই সেটা भी শেয়ার করবেন 23/11/2025 দুইটা আইটেম নম্বর 22 or 20 তারপরে
order of losses has not been complied. The losses is directly the instruction last of it.
Item 24, this is regarding disbursement of the compensation amount in respect of Upper Indravati project matter. My lord, we have filed an IA application seeking 1 month time to comply with the order. But in the meantime, today I obtained instruction from the authorities. They have sent it just now, my lord. They require only 15 days for sanction and disbursement. That I'll produce because I've stated for
learned counsel for the opposite party contender submits that Mr. Das, learned additional government advocate, submits that though the interim application has been filed IA number 394 of 2025 for extension of time to comply the order dated such and such 23/9/2024 passed in WPC number 22414 of 2024. But he has received instruction today that the same will be complied within a period of 2 weeks for
15 days.
15 days. And therefore the matter may be taken up after 15 days. Is this matter? 20 तारीख रखले चलेगा? At least this matter on 20th of November 2025. The learned counsel for the petitioner is present for the
next matter also same.
same. 20 तारीख আছে? 20/11/2025 ଦୁଇଟା 20 ଏଗୁଡା ତ ଆପଣଙ୍କୁ ବୋଧେ ଆସାଇନ୍ ଥରେ ହେଇଗଲେ ଆପଣ ରହୁଥିବେ ନା ନାଁ ଲେଖିବା ଦରକାର ମାନେ ଆପଣଙ୍କ ନାଁ କଜ୍ ଲିଷ୍ଟରେ ଆସିବ ନା ନାଇଁ ଅନ୍ୟ ଅନ୍ୟ କାଉନସିଲ ଚେଞ୍ଜ ହୁଅନ୍ତି
এইটা কজ লিস্টରେ ନାଁଟା ଆସିପାରେ ମାନେ ଏ ଯିଏ
କଣ୍ଟେଣ୍ଟ ମ୍ୟାଟର ଆଗେ ଥିଲା ଯେ ଯାହା କରାଉଥିଲା ସେ ହିଁ ତାକୁ ମାନେ ଡିଲ୍ କରୁଥିଲା ଯେତେବେଳେ ବି ଆସୁଥିଲା ନା ଏବେ ଆପଣଙ୍କର ଚେଞ୍ଜ ହେଇଯାଇଛି ସେମିତି ଯିଏ ସେ କୋର୍ଟରେ ରହିବ ସେ କରିବ ଏମିତି କିଛି ଅଛି କି
ନାଇଁ ସେମିତି
there is a purpose behind it because contempt ରେ ଆପଣଙ୍କୁ separately you are that was the otherwise he has to engage his own so ସେଥିପାଇଁ ଆପଣ ପଚରା ହଉଛି ଯେ if he has engaged you on his own
not on his own as a state council only I am appearing I should not have appeared but it's invariably in all state matters
I will say that in view of the decision of this court
yes
that you should talk to the learned advocate general also that if there is no bar in the state council appearing but for that a separate remuneration is to be paid by him
yes
not it should not come from the state fund
and they should also engage through a wakalatnama normally
yes wakalatnama apanko state panel lo bi engage kari paranti but they have to pay the and state is not to there is a specific
yes
order in that aspect.
And contempt matters the learned advocate general is the prosecutor on behalf of the as per the high court rules so normally ame appear kariba katha nuhe
No, you are mentioning it, but I think that perhaps the arrangement is that they are paying you, so that is how you are mentioning. Otherwise, the decision is very clear that you cannot appear.
We cannot.
Yes.
Receive that copy of instruction. সেটা furnish କରିବି।
हाँ हाँ
ଖାଲି copy।
ଆମେ ତ ଲେଖିଦେଲୁ ଯଦି ପାଇଛନ୍ତି ଯୋଉ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା କହୁଛନ୍ତି
ଏଇଟା ସେଇ ଯୋଉ
ସେଟା ଦେଇଦେବେ ଆମେ ନୋଟ କରିଦେବୁ ଯୋଉ 15 ଦିନ ମାଗିଛନ୍ତି ପୁରା।
ଏଇଟା ଆଇଟମ ନମ୍ବର 25 ରେ ମିଳିଛି। 24 ରେ ଆମେ ଆଇଏ ଫାଇଲ କରିଥିଲୁ।
ହଁ ନାଇଁ ନାଇଁ ଠିକ ଅଛି 25 ରେ ଯୋଉଟା ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଛନ୍ତି
ଆଜ୍ଞା।
15 ଦିନ ଲେଖା ହେଇଛି ତ
15 days।
ସେଇଟା ଲେଖିଦେଲେ କିଛି ଅସୁବିଧା ନାହିଁ।
ଏଇଟା ଖାଲି ରେକର୍ଡ ରେ
ହଁ ରେକର୍ଡ ରେ
ଏଇଟା କପିଟା ବି ଦେଇନି।
ମୁଁ ଦେଇ ଦଉଛି କପି ଆଇଏ କପି।
26 item 26.
ହୁଁ
This appellant number 1 was not released. That's a report was got for. In the meantime, it released.
there are
Other
four
reports were other-
appellants
Again.
and we have mentioned in the order dated 21/8/2025
Again.
that the Learning Additional Standing Council appearing for the state has produced the written instruction received from officer in charge of Badam Park Police Station, which reveals that appellant number 1, Rufa Jari, has been released from jail and he is present in his house. Similarly, 2 and 4 are present in the house. So far as appellant number 3, Ghaziram Jerai is concerned, he has absconded since 2003 and his whereabouts is not known. The order dated so and so, it appears that while rejecting the bail application of appellant number 1, the other 3 appellants were directed to be released on bail. Submit that he has instruction appellant number 1 has been released prematurely. That is how he is now available in the village, even though he has not been released on bail. So that is how you
Obtain that instruction.
on asila instruction.
The naturally released, it transfer to the.
ঠিক আছে পুলিশ গুলি জানে জনে তো সেই রূপা
জরে।
জলে
26/7.
আর দুজন কিন্তু জামিন দেন।
Transfer to subsequently Jamujari, there she has released.
କିଏ
Rupajare.
ହଁ ନାଇଁ ରୂପା ଜଳି ତ ରିଲିଜ ହେଇଗଲା ବାକି ଯୋଉ ଅନ୍ୟମାନେ ତ ଆଭେଲେବଲ ଅଛନ୍ତି ନା ଗାଁରେ
ହଁ ପୁରା ଘାସିରାମ ଟା
ଖାଲି ସେ ଗୋଟେ ଲୋକ ନାହିଁ କୁଆଡେ ଯାଇଛି ଲେଖି ଦିଅନ୍ତୁ the learning council for the as per the order ଏମିତି ଦେଖନ୍ତୁ as per the order dated 20/8/2025 the learning council for the state has produced the written instruction received from Superintendent Biju Patnaik Open Air Ashram, Jamujhari, which indicates that appellant number 1, Rufa Jhare, has been released prematurely by the order of the government. The copy of the order has also been annexed to the instruction. The documents filed by the registrar taken on record. So we can hear the matter for 2, 3 and 4. And suppose the result of the appeal so desires, so ultimately appellant number 3 will be again, he has absconded, so will be taken into custody otherwise. Yes, Mr. Das. So you mainly focus on now 2, 3 and 4.
Yes.
no response from the, anyway. In the other appeals which have been listed, in any case, you have received an instruction. These are all old appeals. Hearing senior was a hearing.
report ଆସିଗଲା ପରେ
ଏଗୁଡା ସବୁ ଚେକ୍ ହେଇଯାଇଛି
ଆଗରୁ report
ଠିକ ଅଛି ମୁଁ ସେଇ
ତାପରେ ଏଟା list
କାରଣ ଆମେ ଅର୍ଡରରେ ଆଣୁଛୁ ଚେକ୍ ହେଲା ପରେ ହିୟରିଂ ରେ ପଡୁଛି ମୁଁ ସେଇଆ କହିବା କଥା ଯଦି ହିୟରିଂ ମ୍ୟାଟରରେ ଯେତିକ ଲିଷ୍ଟ ହେଇଛି ସବୁଗୁଡା ଚେକ୍ ହେଇଯାଇଛି ଦେ ଆର୍ ଆଲାଇଭ୍ ତ ଠିକ ଅଛି ତ also ask the learned counsel to get ready. Mr. Das to ଅଛନ୍ତି ତାପରେ item Mr. B.K. Mahanti N.K. Praharaj with HMT Mr. A.K. Chaudhary is also.
last occasion I have intimated to Mr. Das sub item. He told that this son of Mr. Chaudhary will conduct the case.
ठीक है जी
71 to 31.
हाँ
71.
What about this B.S. Raiguru?
That is
Cricket.
You are there, okay. So item number 28 is ready.
29 was also
29 also ready.
ready.
Okay.
Yes, sir.
You are ready for production. And 30 तो देवाशीष षडंगी थिले the last time. ठीक है जी sufficient होगा. चलो मैं ये दियो पेपर बुक दियो. এটা শুনানি আরম্ভ হয়েছে না না আজই আরম্ভ হবে
26টা
হ্যাঁ হ্যাঁ
26টা ইনস্ট্রাকশন পাইছে
না না ঠিক আছে আমি জানিয়া যেমন পেপর হ্যাঁ
ଆଉ ଗୋଟେ ଡେଟ୍ କୁ କାଲିକି
କାଲିକି ନୁହେଁ ତ ଆମର ମଙ୍ଗଳବାର ଆଉ
ମଙ୍ଗଳବାର ନୋଟ୍ କରି ଦେଇଦେଇକି
ଆଚ୍ଛା
ଗୋଟାଏ ଦିନ ମଧ୍ୟରେ
ନାଇଁ ନାଇଁ ଠିକ ଅଛି
ସେଥିରେ ଆଉ ଦିଟା ଆଉ ଗୋଟେ କନେକ୍ଟେଡ ଆକ୍ଚୁଆଲି ଗଙ୍ଗାଧର ସାହେବ
ଆଦିରେ ଆର କନେକ୍ଟେଡ ଅଛି
ନା 27 ଗଙ୍ଗାଧର
ଅଛି ନା 27ଟା
27 ବି
ନାଇଁ ନାଇଁ ମୋର ନାହିଁ ସରି 26ଟା ମୁଁ ଅଛି
ହଁ 26ଟା ତ
26 ସିଙ୍ଗଲ
ସିଙ୍ଗଲ ଅପିଲ ନଟ୍ କନେକ୍ଟେଡ
ସିଙ୍ଗଲ ଗୋଟେ ଲୋକ ବୋଧେ ରିଲିଜ ହେଇଯାଇଛି ଆଉ ଅନ୍ୟମାନେ ଅଛି
ହଁ ସେ ପ୍ରିମ୍ୟାଚୁର ସେଟା ତ ଭେରିଫାଇ ହେଇଗଲା ନା ବର୍ତ୍ତମାନ ଏଇ ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ରିଲିଜ ହେଇଗଲା ପ୍ରିମ୍ୟାଚୁରଲି ଆଉ ତିନିଟା ଅଛନ୍ତି ତିନିଟା ବେଲ୍ ଅଛନ୍ତି ଗୋଟେ ତା ଦେହରୁ ଫେରାର ହେଇଯାଇଛି ସେ ମାନେ ବେଲରେ ଗଲା ପରେ ଆଉ ଗାଁରେ ରହୁନି whatever it may be there is no problem in hearing the criminal appeal ତେଣୁ ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ
I will also take instruction about it.
ହଁ ବାକି ସୋ ଇଏ ପଡିଗଲା ନେକ୍ସଟ ଆଇଟମ ଯୋଉ କହୁଥିଲେ
28 Mr. Naik.
28 part है
Yes, Raiguru.
Yes, Mr. Raiguru. Item 20 is what?
Last four items, that is two items, three items.
Yeah. What are those?
Item five.
ଓ ଏଇ ଯୋଉ ଆମେ 5 ନମ୍ବରର ତିନିଟା ଆଇଟମ ପାସ୍ ଓଭର କରିଥିଲେ ଦିଅନ୍ତୁ କଣ ଆସିଲା 5 ନମ୍ବରଟା ସାହୁ ବାବୁ ନେଇଥିଲେ ଗୋଟେ ଆଇଟମ ନେଇଯାଇଥିଲେ 69 ଟା ଆଉ ବାକି ତିନିଟା
93, 91 and 92.
ହଁ ଦିଅନ୍ତୁ 73 ଟା ଦିଅନ୍ତୁ
The report has been. We are sending a
Asini,
letter, but
tinta
report
karke.
has not been.
73 ରେ ଆସିନି 91 ରେ ଆସିନି 92 ରେ
92
ଆସିନି ଏ ଯୋଉ ସାହୁ ବାବୁ କହିଦେବେ ଏ ତିନିଟାରେ ତା ଦେହରେ ଲେଖିଦେବେ ଯେ the learning council for the state submits that though the well-being report of the appellant so and so has been sought for but the same has not yet been received some more time is necessary ହେଲା 2 ସପ୍ତାହ ପରେ ରଖୁଛୁ ତାକୁ 10th ରେ ରଖିଦିଅନ୍ତୁ 10 ମାନେ 11th ରେ ରଖିଦିଅନ୍ତୁ 11 ନଭେମ୍ବର ରେ ଆସିବ ଏ ତିନିଟା ମ୍ୟାଟର ଆଉ ତା ସେଇଟା ବି ଆସିବ ଯୋଉ ପ୍ରଥମଟା ଫାଷ୍ଟ ଆସିବ ହଁ ତାକୁ କେବେ ଆମେ ଦେଇକି ଯଦି ବି ଅର୍ଡର କରୁଥିବୁ ନେକ୍ସଟ ୱିକ୍ ତାକୁ କରିଦେବେ 11 ହେଲା ଏ ତିନିଟା 26 ଟା ଆଜି କେତେ ହେଇଗଲା Mr. Das, we are taking up this item number 26
Yes.
on Tuesday
Yes.
of 28. Mr. Das, Lenin, senior advocate appearing for the appellant. submit that the matter may be taken up next week. Place this matter on 28/10/2025 for the hearing, है ना? शीतल जी उठा कर दिल एक नंबर जो जाए तापर लिख लो तापर मिस्टर रायगुरु Yes. Already had the matter. I am today I am filing the we are just coming within 2 minutes. Yes, no.
On file करते हैं।
The last occasion of lawsuit extensively had the matter. I have found out some discrepancy. I have given some citations as well as pointed out the discrepancies in the evidences of the eyewitnesses.
PW4 and PW8
4 and 8, madam.
are the two eyewitnesses.
Yes.
If we remember that correctly, that the occurrence took place on 12th of night.
Night.
And out of the two witnesses, one was examined by IO on 15th.
Yes.
2 days after.
Yes.
The other was examined after 8 days after, that is on 20th.
Okay.
Thereafter also their 164 was
Yes,
recorded.
yes.
They have given some explanation. One says that I had been to Raurkela or something like that.
Other is Bhubaneswar.
The other says Bhubaneswar. But that explanation, what you submitted on that day, that it is not acceptable and such explanation, it shows that one of them had also come to the house of the deceased on that day.
That an informal, sir. One of his brother.
They intimated and the brother was intimated, and the time the investigation has already commenced.
Yes.
But in spite of that, without giving his statement, he went to Raurkela.
And one of that eyewitness also went to the Govindpur police station, one of his relative, 400 meters away.
They are right.
Yes.
They were staying, one says that I was staying at a place which is just 400 meters away from the police station.
Yes.
I was staying in the house of Mr. A. But on the next day, I was got mentally perturbed. तापर दिन 10टा बेलू मोर मानसिक अवस्था ठीक है ता सत्वे मध्य मु थाना को गलिनी मु चली आइली आंको घर को घरे आसिक इंटिमेशन देली तीनटा इतना ना बट बाय दैट टाइम द इन्वेस्टिगेशन हैज ऑलरेडी स्टार्टेड
Yes.
आउ जहा को इंटिमेशन देला से लोकर 161 रेकॉर्ड हेची 4:15 रे जोटा को देखुची जे सेमती किछि इंफॉर्मेशन आसीनी से भी जानिनी जे किए माने ये कला से माने भी जानिबा को चेष्टा करछन
From the 161 statement of the PW2 reveals that as if he has not known anything.
Right. At least till
4 p.m.
4 p.m. So that shows that the intimation which is stated to have been given to him by PW4 appears to be not correct. That was the submission.
But PW8 statement.
PW8 टा पळेला पर एठी की
भुवनेश्वर ना भुवनेश्वर
गोटे गला भुवनेश्वर की
भुवनेश्वर गला PW8
8 गला भुवनेश्वर 4 गला
राउरकेला
अच्छा 8 गला राउरकेला
ना 8 गला भुवनेश्वर
और 4 गला राउरकेला अच्छा जो राउरकेला हाँ आउ गोटे एविडेंस आपन कहले जे राउरकेला से जाई कोठी रहिला कहा घरे रहिला कोठी डिस्क्लोज कला तार किसी एविडेंस नहीं सिमिलरली भुवनेश्वर को जो गला
सांग घरे
रादर तार 161 देखुची कोन ताको की कहला जे पार्टी कला तू कला तू जा ये
जो सांग घरु जाइतला से सांग पार्टी कला तुरंत जाई कि
तापर म आसिल
so there is what if we correctly understood that your submission is that the explanation which has been given by these two witnesses it appears to be not believable.
Yes.
Because there is no corroborating material and one who had stated to have disclosed before PW2, he is PW4, but PW2 statement is completely silent. In 161 there is nothing, rather 161 was recorded after he made the disclosure, which shows that the names of the persons are not there. So,
my submission is, even if there is some discrepancy in the statement of PW4 and PW8, but the occurrence part, that is consistent with the evidence of PW4 and PW8.
No,
occurrence part, my lord.
Everything, Mr. Nayak,
My lord.
once we, what he says, that occurrence part would be consistent. There is no problem in that. But once, why in so many decisions, the importance has also been given that the court has to see why the witnesses gave a statement before the police at a belated stage. What is the explanation? And whether that explanation is acceptable or not. Why the court have also given emphasis on that.
My lord,
The question is that once you delayed, there is every chance of concoction of the case. So therefore, once, yes, if the police agency was not available to you, or there is some thing which appears to the court that yes, for this satisfactory explanation, it was not possible on his part during that period to give his statement to the police, or the
On this
reasonable
point,
explanation
madam,
has been given.
On this exact point, madam, our High Court decision.
Just a minute, we will go to the High Court, we know that. So the once the prosecution explanation is found to be not satisfactory, then that may be also a ground
my lord.
to disbelieve the witness, even the version of the witness otherwise appears to be consistent.
At this stage, my submission is the accused person, they have threatened the witnesses, number one. Number two, the witnesses have also criminal background. By that time, their apprehension that either they may be killed by the accused person or police may implicated them also in this case as an accused.
No,
Because-
we pose the question, Mr. Nayak, we pose the question that if in spite of the threat given, they are remaining in that area, they are coming to the house of the deceased, disclosing according to them, they disclosing before others. So that shows that that threat part has no such impact on them. So if they have gone to this much, then what is there not to disclose before the police was available there? Police has already started investigation.
Only PW4 stated that he came to village, but PW8 has not. କେବଳ PW4 କହିଛି ଯେ ସିଏ ଗାଁକୁ ଆସିଛି ଯୋଉ ଦିନ ଘଟଣା ହେଲା ନେକ୍ସଟ ଡେ ଦୁଇଟାରୁ ତିନିଟା
ମାନେ
they belongs to one
ଆଚ୍ଛା 8 ମଧ୍ୟ କହୁଛି I am very close with the family, I am the friend of, I think, the brother of the deceased or something like that, he has stated. And he had also, he was there near.
No, he fled away to Bhubaneswar.
ନାଇଁ ସେ ଷ୍ଟ୍ରେଟ୍ ଯାଇନି ଭୁବନେଶ୍ୱର, ସେ କୋଉଠି ଗୋଟେ ରହିକିନି ତାପରେ ଭୁବନେଶ୍ୱରକୁ ଯାଇଛି।
ସେ PW8 କହୁଛି।
PW8 ର ଦେଖନ୍ତୁ ଆପଣ, I think we that on that day PW8 ର statement ରହୁଛି
PW8 stated that at page 69, last para, the accused Madha Kodutia threatened me and to Bapi, PW4, not to disclose about the occurrence to anybody.
You come to page number 70 ର paragraph number 11.
Yes.
This is the evidence of PW8. Paragraph 11 ର say you leave myself PW4 and all the accused persons left. I went away to a different direction while the accused person and PW gala. While going through the cremation ground, I fell down. No injury received. I lie down there. So and so. It was about 4 a.m. in the night. Later on, I proceeded ahead and went to the house of Ramchandra Parida through the barrel land. I told everything about the occurrence to Ram Parida. Ram Parida has not been examined.
Yes.
तापरे एटा होची एग्जामिनेशन इन चीफ रे गला तापरे आपण पळे आसंतु क्रॉस एग्जामिनेशन को अच्छा क्रॉस एग्जामिनेशन पारा 13 टा देखो आई हैव विजिटिंग टर्म्स टू द फैमिली of the deceased since my childhood. The elder brother of the deceased is a friend. So he was very close
Yes.
to the family. It's not a XYZ mala more kon achi. But this man was very close to the family of the deceased. And according to him, he has seen the commission of murder. Hala? Now you see the next paragraph 14, जोटा कि हमें underline करछि. Statement record है 15/3 रे.
Yes.
14/3/96 रे 8 ରୁ 9 दिन 8-9 बेलू सी आसिला पुलिस स्टेशन. पुलिस स्टेशन ने रहिला.
पुलिस
ଆଉ ରହିକିନି 24 ଘଣ୍ଟା ପରେ ସେ पुलिस स्टेशन ଛାଡିଲା. ତାର statement record ହେଇଛି 15 ତାରିଖ. ଆଉ I was detained by the police to bring me into the court. ତାକୁ 24 ଘଣ୍ଟା ଅଟକା ହେଲା, ତାକୁ ଛଡା ହେଇନି, ଅଟକା ହେଇଥିଲା କୋର୍ଟ କୁ ଫରୱାର୍ଡ କରିବାକୁ. Most likely statement ଦେଲା ହେଲା ପରେ ଆଜି witness ତାକୁ
My humble submission is this, my lord. This is the apprehension of this witness. That's why he fled, because he is of criminal background. He knew that if he will be apprehended, police may implicated him in this case, and that apart the mother threatened the 15 दिन पर्यंत him देखा नथी.
No,
They all this time.
what he submitted, since the material had come by that time, that these two persons had accompanied the deceased.
Yes.
Right? So, therefore, the police was suspecting the involvement of both PW4 and PW8
Yes.
in the commission of the murder. So, that is the reason why this man was also detained for 24 hours. So, the moment he gave the statement on 15 that he is a witness, he is not an accused, and X and Y have committed the offense, thereafter he was let off.
Yes.
So, if he is a witness, he would have given the statement on the 14th itself. Why he disclosed it only on 15th? Why not on 14th? If he had gone, of course, this is not stated by the police. IU has not stated that on 14th he came and we detained him up to this witness voluntarily he said in the cross examination that I came there, remained there for 24 hours. And I was detained to be forwarded to court, and that is the reason.
Otherwise, he is saying that soon after my arrival at PS, my statement was recorded. His statement was recorded as soon as he arrived in the police station, not for the purpose of statement. So it is only to be produced before the court he was detained, if at all, because it is a question in the cross examination.
So virtually these are the submission to disbelieve the witnesses. So, and he has perhaps brought some decision on this delayed disclosure or this. So,
page 25, exactly the point Lordship marked up.
25?
Page 25.
25
of my compilation. And this honorable court acquitted in this case.
just a minute. Munalal versus state of.
No, just the purport distance.
Page 25 purport.
25 is.
State of Orissa versus Brahmananda.
Brahmananda Nanda state of Orissa versus Brahmananda
Bhagavati jota है.
Petition ta.
Kind Bhagavati का जो.
ସେ କହିଲେ ଯେ ଯଦି ଗୋଟେ ଆକ୍ୟୁଜ ବି
କୁହନ୍ତୁ ମ
ପାରା ଥିଲେ
ବ୍ରହ୍ମାନନ୍ଦ ନନ୍ଦ.
yes ma'am,
that is
this honorable court acquitted the accused but state
ଓଡ଼ିଶା କେସ୍ ଟା ନା
ଓଡ଼ିଶା ଏଥିରେ ସେ କହିଲେ ଯେ
डेथ सेंटेंस इतला जोटा सेटल
sole eyewitness testimony in murder case credibility when witness names accused over a day after alleged incident despite circumstances where prompt disclosure would be expected and reasonable opportunity.
There are other aspects. In that case, there was other discrepancies.
Due to threat.
You come to paragraph number 2 of that judgment which you are relying upon. Brahmananda Nanda.
Yes, sir. I am placing that. The entire prosecution case against the respondent rests on the oral evidence of Chantala, PW6, who claimed to be an eyewitness to the murder of Hrudananda, one of 6 persons alleged to have been killed by the respondent. The learned additional session judge believed her evidence, but the High Court found it difficult to accept her testimony. The High Court has given cogent reasons for rejecting her evidence, and we find ourselves completely in agreement with those reasons. We have carefully gone through the evidence of this witness, but we don't think we can place any reliance on it for the purpose of founding the conviction of the respondent. The evidence suffers from serious infirmities which have been discussed in detail by the High Court. It is not necessary to reiterate them, but it will be difficult.
It will be sufficient.
It will be sufficient if we refer only to one infirmity, which, in our opinion, is of the most serious character. Though, according to this witness, she saw the murderous assault on Hudananda by the respondent, and she also saw the respondent coming out of the adjoining house of Nityananda, where the rest of the murders were committed. She did not mention the name of the respondent as the assailant for a day and a half. The murders were committed in the night of 13th June 1969, and yet she did not come out with the name of respondent until the morning of 15th June 1969. It is not possible to accept the explanation sought to be given on behalf of the prosecution that she did not disclose the name of the respondent as the assailant earlier than 15th June 1969 on account of fear of the respondent. There could be no question of any fear from the respondent because, in the first place, the respondent was not known to be a youngster or a confirmed criminal about whom people would be afraid. Secondly, the police had already arrived at the scene and they were stationed in the clubhouse, which was just opposite to the house of the witness. And thirdly, ASI Madan Das was her nephew, and she had come to the village in connection with the case and had also visited her house on 14th June 1969. It is indeed difficult to believe that this witness should not have disclosed the name of the respondent to the police or even to ASI Madan Das, and should have waited till the rooming of 15th June 1969 for giving out the name of respondent. This is a very serious infirmity which destroys the credibility of the evidence of witness. The High Court has also given various other reasons for rejecting her testimony, and most of these reasons are, in our opinion, valid and cogent. If the evidence of this witness is rejected as untrustworthy, nothing survives of the prosecution case.
My lord, this judgment is not applicable to this case because, my lord, in this case there is no threat to the witness. In the present case, there is no threat to the witness, whereas in the case we are hearing, my lord, in this case threat was there. Number two, one ASI Madan Das is a relation of the witness. Here there is no relation. Number three, the police personnel came and stationed at the clubhouse, which is just adjacent to the house of the witness. But in this case, there is no evidence. The police has arrived at the house of PW2 when
police has started investigation.
Investigation.
That evidence.
And he had been to his relative house, which is beside the police station, 400 meters. से पाखरे रहिथिले
नहीं से गारे विभिन्न पुलिस भी जाइछन्ती कलेक्शन करूछन्ती माने अछि जे नीड से विसिनिटी रे अवेलेबल अछन्ती.
The only aspect which appears here is the apprehension of the witnesses to get themselves implicated in the case.
Yes.
They being one of the, because the fact that they had accompanied the deceased was not in dispute.
Yes.
They had accompanied. So they were very much, and having regard to the antecedents they have, there was very likely that they may also have been implicated. So they had a fear in themselves. Not that the fear was instilled by someone else. It was in themselves. That is how they tried to avoid initially.
And the accused person have no enmity with the PW 4 and 8.
But thereafter, in Munna Lal case versus state of Uttar Pradesh, in here also, the
आपण लेक्चर paragraph number
39, 40, 41. my lord. Or in 39. Secondly, though PW4 is said to have been reached the place of occurrence at 1:30 p.m. on 5/9/1994 and recovered a bullet in the blood oozing out from the injury of the tip of the dead body, no effort worthy of the consideration appears to, my lord, this I am giving as because, my lord, as these witnesses, these eyewitnesses, my lord, their evidence are not wholly neither wholly reliable nor wholly unreliable. my lord. In the third category, they are coming. So, in order to prove this, my lord, so the prosecution should have been corroborated their each and every circumstances also, my lord. Wherein in the present case, my lord, the weapon of offense which has been used for commission of the crime, that has not been produced before the court, that has not been seized, that has not sent to the chemical examination. Same weapon of offense used by three, as alleged, my lord, three accused persons, but that has not been seized. That pistol also, though it was not used, that has not been seized. So there is lacuna in the investigation, my lord, and which doesn't corroborate their evidences, my lord. So, my lord, on that point, I have relying on the Munalal case, my lord. That is also there. I am placing, my lord. In blood oozing out of at the hip of the head, no effort worthy of consideration appears to have been to seize the weapon by which the murderer's attack was launched. It is true that mere failure, but this is also the Honorable Supreme Court pointed out, mere failure or neglect to effect seizure of the weapons cannot be the sole reason for discarding the prosecution case, but the same assumes importance on the face of the oral testimony of the so-called eyewitnesses, that is PW2 and 3, not being found by this court to be wholly reliable. The missing link would have been provided by the investigating officer, who again did not either the witness whether or not examination of a witness has caused prejudice to the defense is essentially a question of fact, and an inference is required to be drawn having regard to the fact and circumstances obtaining each case. The reason why the investigating officer could not depose as a witness, as told by PW4, is that he had been sent for training. It was not shown that the investigating officer, under no circumstances, could have left the course for recording of his deposition in the trial court. It is worthy of being noted that neither the trial court nor the High Court considered the issue for non-examination of the investigating officer. 40. In the fact of the present case, particularly conspicuous gaps in the prosecution case and the evidence of PW2 and 3 not being wholly reliable, this court holds the present case as one where examination of the investigating officer was vital, since he could have adduced the expected evidence. His non-examination creates a material lacuna in the effort of the prosecution to nail the appellants, thereby creating reasonable doubt in the prosecution case. 41. So, as far as non-obtaining the ballistic report is concerned, it is no doubt true that its essentiality would depend upon the circumstances of each case. Here, since no weapon of offense was seized, no ballistic report was called for and obtained. Although Mr. Giri contended that Munalal had a licensed gun, this court has not been able to trace any evidence in the records in regard thereto. However, nothing turns on it. The failure or neglect to seize the weapon of offense on facts and circumstances of the present case has the effect of denting the prosecution story so much so that the same, together with non-examination of the material witness, constitutes a vital circumstance amongst others for granting the appellant the benefit of doubt. In this case also, my lord, the IO has not been examined, the other IO. There are two IOs, my lord. One IO has been examined, but the IO who taken over the charge of the investigation, that he has not been examined in this case.
No, here the weapon of offense is sword.
Yes, my lord.
The sword was not seized.
Not seized.
From these two persons who were arrested. One was absconding. So,
Even if totally judgment rendered by the London trial court, so also in the entire story, that has not been discussed also. ତା ବିଷୟରେ କିଛି weapon of offense ରେ କିଛି discussion ବି ନାହିଁ. Only eye witness କହିଛନ୍ତି ଖଣ୍ଡାରେ ସେ ହେଲା, ସେ ତାଠୁ ମାଦ ତାଠୁ ଛଡେଇଲା ମଳ.
No, that is how the medical evidence has come on record.
Medical evidence is there.
Nature of injuries is
Yes. Yes, that is right, madam. But the evidence of the sole eyewitnesses are
No,
discrepancy.
it is not circumstance, sir. It is purely on the
If
evidence.
they
direct.
are wholly reliable, madam, there is no need
No,
of
that is different, but this is not a case of circumstantial evidence.
No.
It's a case of direct evidence.
Yes, sir, direct
That
evidence.
is how
But
the court need not have to go to
if-
other aspects.
if the-
Once the witnesses are not reliable, then case go on.
Yes.
If the witnesses are reliable, then case is there.
My humble submission is that as the witnesses are neither wholly reliable, not therefore it needs corroboration, madam, of the circumstances.
No, these circumstances need not be, because the medical evidence clearly spell out that the nature of injuries are by sharp-cutting weapon.
Yes.
And that is not disputed by the defense. It is not disputed. The nature of death is not disputed. The manner in which the injuries were suffered by the deceased has not been disputed. So these aspects goes without.
And the my lord, another decision, Ramesh Baburao Deva Sarkar versus State of Maharashtra, my lord. This is also the effect of recording evidence in Delhi, my lord. That is also I have given.
এইটা খুব পয়েন্টে দিয়েছেন যে বাড়াকৃষ্ণ স্বামী ভার্সেস স্টেট অফ ওড়িশা
সেইটা effect of delay.
ডিলে বাকি মারুতি রাম্য নায়ক
সেটাই তার ভিতরে আছে।
ডিলে রে তাদের এগুলা ସବୁ ডিলে উপরে দিয়েছেন
ডিলের ଦେଇଛି ଆଉ ଏଇଟା ନନ୍
ବ୍ରହ୍ମାନନ୍ଦ ନନ୍ଦ ତ ସେଇ ডিଲେ
ହଁ ସେଟା
ଏଇ ଯୋଉ
ଆଉ ଏଇଟା ଯୋଉ ନନ୍ ଏକ୍ସାମିନେସନ ଆଇଓ ଆଣ୍ଡ ସିଜର ଅଫ ୱେପନ
ନିଜର ୱେପନ
yes ma'am
ତା ଦେହରେ ଆଇଓ ଗୋଟେ ଆଇଓ ଏକ୍ସାମିନ
ଆଉ ଗୋଟେ ହେଇନି ଯୋଉଟା କି ଭାଇଟାଲ ଯେ ଚାର୍ଜ ନେଲା ଇନଭେଷ୍ଟ ଇଏ ଅଧାର ଦେଇଦେଲା ତାକୁ
What is his role?
ସେ କଣ କରିଥିଲା କି
What is his role?
ବର୍ତ୍ତମାନ ଆଇଓ ହଉଛି ପିଡବ୍ଲ୍ୟୁ କେତେ
He examined all the witnesses. After the charge was given, he has only sent the incriminating material to the RFSL and submitted the charge sheet.
Ashok Kumar Das only submitted charge sheet.
13/3/1996 ରୁ 8/7/1996
Yes, sir.
ପ୍ରାୟ 4 ମାସ ଧରିକିନି ଇନଭେଷ୍ଟିଗେସନ କଲା କରିକିନି ଅଶୋକ କୁମାର ଦାସକୁ ଏସ୍ଆଇ କୁ ତାର ହ୍ୟାଣ୍ଡ ଓଭର କଲା who submitted charge sheet. That is the evidence. Charge sheet କେବେ ଦେଖିଲ ଫାଇନାଲ এটা নয় charge sheet
এটা চার্জ এটা ছিল হ্যালো
3/12/97
ये charge क्या होगा?
3/12/97
ପାଇଲେ
1 year
କୋଉଠୁ ପାଇଲେ
पेज
ଫାଇନାଲ ଫର୍ମ ଅଛି
केस डेट ଅଛି
ହଁ କେତେ କାଇଁ
पेज 457
457, submission of charge sheet, yes, sir. That is dated 3/12/1997. 3/12/1997. সেটা কোন করবেন? Forwarded the exhibit সে করেছি।
Only
exhibit
শেষ
করা হয়েছে। 8/7/96 পরে যদিও ପ୍ରାୟ ବର୍ଷେ ପରେ ସିଏ ବର୍ଷେ ଆହୁରି କେତେ ଦିନ ପରେ ସେ କଣ କରିଛି ଏତେ ପିରିୟଡରେ ଏମିତି 8/7/96 ଆମେ ଯଦି ଆସିଲୁ ତାପରେ ଅଛି 4/8/97 4/3/97 ଚାର୍ଜ ହ୍ୟାଣ୍ଡ ଓଭର ହେଇଗଲା 6/6/500 6/4/97 16/4/97 रेड कंडक्ट କରିଛି ଆଉ କିଛି ଜଣ ନିଖିଲକୁ ଆରେଷ୍ଟ କରିଛି
ଚାର୍ଜ ନେଲା 1897
8/7/96 on 8/7/96 I made both charge of this case to my successor Ashok Kumar Das para 10
ନିଖିଲ କୁ ଆରେଷ୍ଟ କଲା 10/9/97
ଇଏ କରୁଛି ନୂଆ ଇଏ କରୁଛି
ପୁଣି ଏକେ ଦାସ ଚାର୍ଜ ନେଲା
ପୁଣି ଦେଲେ since I have been transferred case handover charge to SI AK Das এটা ହେଲା ପୁଣି 97 ମାନେ he was there only for a month received charge of investigation from SIBC section ସେଟା ହେଲା 1/10/97
In the accused statement, of course, you are disputing even to have accompanied the deceased also. That is stated.
accused is not accompanied they are not accompanied
No, witness,
no
witness was
other accused
a witness one of our accompanied to that.
4 and 8 get
Right. It's a question of whether the evidence of these 4 and 8 is to be believed or not believed.
Yes.
And the main reason which according to you is because of this delayed disclosure, the evidence doesn't inspire confidence.
Another point is that they have developed their story in 164 also. 164 ରେ ବି ସେ point ଟା ବି I have given the decision that is there. The developed story delay ହେଲା ମାନେ there is every chance of
No, ye developed to the extent
what is that development
as you know
has it been put to the witness in your 164 statement?
No, I don't know.
चार नंबर टा वाचले देखियो 4 नंबर तो এটা এটা ଆସୁଛି 4 নম্বরটা সে রাউট খেলা বলে না?
4 নম্বর out হলো।
Paragraph number 25 रे पचरा आइची, page 57, so far as PW4 is concerned. I have not stated before the magistrate in my statement under section 164 CRPC regarding the instigation made by accused Madhu Kuntia to assault, and also that he, acha 8 out, instead of point out. এই যে মধু খুন্টিয়ার আমি দেখিଥିଲୁ ବି ସେଦିନ ভেরিফাই কর the one of the appellant মধু খুন্টিয়া actual assault করଥିଲା, that is not there in that 161 statement, and that has been proved also, and it was stated only মধু খুন্টিয়ার ওভারটাইম বিষয়ে সে যে কোর্ট রে কହୁଛି না, that line comes you come to chief examination first. PW4 wrong. Examination in chief, paragraph 10.
When deceased Biranch was groaning
Ah,
for the injuries received by him, at that time accused Madhakuntia took the sword from the co-accused absconder accused and said Madhakuntia also by means of sword on the person of the deceased Biranchi.
okay. And now you have bahar korchanti contradiction,
Paragraph 25.
para 25. I have not stated before the magistrate in my statement recorded so and so regarding instigation, so and so, and that he assaulted the deceased. He has admitted, and we have checked up also that day, and out of এইটাও দেখুন paragraph page number 59 34. It is not a fact, paragraph 31 asile, it's not a fact that I have not stated before the IO that when the deceased was groaning, say your statement like that, after being assaulted, accused Madhu Kuntia snatched away the sword from the co-accused, assaulted the deceased with the said sword, and that the place of swan sword. It is not a fact that I have not stated before the IO that accused Madhu stated that while threatening, saying that he would destroy the housemaid. This has been proved by them through the IO and verify madhya karithulu boli setna. Okay, that. You come to
Paragraph 25.
paragraph 25, page 82. PW4 did not state before me regarding the assault by the accused Madhu Kuntia on the deceased. PW did not state the accused gave out the identification of PW4, so and so. Again, paragraph 26, PW8 did not state before me that accused Madhav assaulted the deceased. Hala? So both the eyewitnesses, though in court, have attributed specific overt act against this appellant Madhu Kuntia to have assaulted the deceased by means of a sword snatching from the other appellant, but such statement is not there in the 161 as well as 164. Because it's a vital contradiction. Because the presence is there, but ये जो overtax जोटा तेणु सी अन्य आस्पेक्ट सहित जो डिलेड डिस्क्लोजर सहित ये आस्पेक्ट टाकू मध्य he is highlighting. That
But
is
the
why he said,
presence of Madhav Kuntia.
no, his submission that why we are posing that why he has pointed out that decision that he cannot come within that category of absolutely reliable witness. Because in a 302 case, even though he has not implicated one of the accused who have assaulted the deceased by means of sword after snatching it, not only stated before the IO, even in the 164, but such a statement is given for the first time in court. That is the reason why I say that you cannot, both the witness cannot come within that category of absolutely reliable witness. Set out the submission.
Yes, my lord. Even if the assault part by Madhav Kuntia is not accepted, still presence of Madhav Kuntia is not disputed. Madhav Kuntia is the person who was very much present there. He called the deceased to the place of occurrence. He called the other accused person to the place of occurrence.
Deceased place of occurrence कौन?
से रास्ताରେ ଅଟକେଇଲେ ଅଟକେଇ କିଛି ବାଟ ନେଇକି ଯାଇଛନ୍ତି ମାଧବ ଖୁଣ୍ଟିଆ ଡାକିକି deceased କୁ ସେ
ମାଧବ
ଅଟକେଇଲା
ତାପରେ କହିଲା ଯେ ତୁ ଯା ସେ ଯୋଉ ୟାକୁ ଡାକିବା ପାଇଁ ଯୋଉ ଗାଡି
ଟ୍ରକ୍ ଡ୍ରାଇଭର କୁ
ତାକୁ ଛାଡିଲା ବିରଞ୍ଚିକୁ ସାଙ୍ଗରେ ନେଇକି ଗୋଟେ ଜାଗାରେ ବସେଇଲା
ଅନ୍ୟ
ତାପରେ
accused ମାନଙ୍କୁ
ଗଣକୁ ଡାକିଲା ସେ ଭଣ୍ଡା ଧରି ଆସିକି ତାକୁ
this part is not disputed. It is accepted by the defense also. Therefore, even if Madhav Kuntia has not assaulted, but his active role cannot be discarded.
No, अपन को segregate जो portion दी, ताकि grain from the chaff हमें काटी दो, seed portion का काटी दो, but एक जिनिसटा देखियो पड़ो how far you can convince that this is an absolutely reliable witness. एक category आसी परियो कि से type of witness जे कि अन्य जिनिस कोची जन गोटे accused को implicate the direct assault by sword ए जोटा ए भड़िया witness in a case of 302 जार की अन्य features कोची and can you that is his submission that can he come within the category of absolute reliable witness काहे कि ना हमें यदि PW4 टाकू यदि सही ग्राउंड रे हमें ये करजु ए जो 8 दिन परे आइला राउट केला परतला तेणु आपण पर गोटिए मात्र विटनेस रही जाउ PW8 से PW8 रो जे कि even though he has not stated in 161 164 attributing specific overt of assault against the Madhav Kuntia and implicating him for the first time in court. Presence ठीक है almost also. से witness टा को यदि absolute reliable category न आसीबो बा let us say absolute unreliable भी न आसीबो से जो मझी category ले partly reliable और partly unreliable हो सेठी ये जो circumstance गुड़ा कर होची तार मध्य 3 दिन डिले होची 3 दिन डिले corroborating evidence नहीं जो रामचंद्र खुंटिया को जाई कहितला
दादा को एग्जाम करने क्या घर जाई से रहितला
no one aspect that all the decisions that you have given is a eyewitness. Here the difference is that they are there in the scene of occurrence. There is a difference in all those. Here the witnesses might have seen which are disbelieved because they deposed later on implicating the accused persons. Here the presence of these witnesses are not denied. They are seen in the occurrence. That is not denied.
In third judgment,
so the only aspect is that they did not divulge the fact immediately, though they had scope, and they divulged it later on. So could it be said that these people, having been in the scene of occurrence, could have implicated somebody else? Because you are not disputing the presence of these persons. It is there that all the three went together in the motorcycle. Madhav stopped them. So in the place of occurrence, these two witnesses were very much there. So that is not in dispute. Once that is not in dispute, the mere fact that they divulge the name of these persons or the manner of occurrence, because occurrence is also consistent, the manner of occurrence and implicating the accused persons could be anybody else. There only these evidence of these two persons can be disbelieved, if at all, to say if they have stated belatedly. So what is the nature of witness here? What is the nature of witness in other cases? In other cases, what has happened in all other cases, where the witnesses have named a person being eyewitness. Here there is participation. The only difference is that.
And in 313 also, the accused person have also not stated that the witnesses are also accused.
Yes, yes.
They have also not stated.
So there is little difference in it. That is a witness who has named belatedly, being an eyewitness to the occurrence, not being in the scene of occurrence. Here, the witnesses are in the scene of occurrence, being part of that, and the assailants have left these two people and murdered the other one. That is whole thing. How you differentiate that?
In third judgment matter, what I am saying, Ramesh Baburao,
What is that?
in that matter, it is also on that part, improvement made in subsequent statement, section 160.
No, those are all witnesses again, I am saying.
Yes, sir.
The improvement in the statement 164 of examination chief is different. They are all witnesses. And here they are not simply witnesses. They are also the persons not admittedly to be in the scene of occurrence. How now you can discard them? You can discard only when.
Question that has been posed to you, that when in view of the number of statements that has been, that you accompanied the deceased, you means I think PW4 and PW8 accompanied the deceased. This court does not find anything to discard that part.
Right.
Then the presence of these two at the scene of occurrence cannot be doubted in that way. The question is that whether merely because they were present at the scene of occurrence, it is to be believed that whatever they are telling is truthful,
yes,
or that they might have exaggerated something. So if that is so, then what is that part of exaggeration? And that is
what is the extent?
And to what extent? One thing, of course, the exaggeration relates to
the implication to assault. Yes.
Criminal conviction basis cannot be based on suspicious affair, unreliable eyewitness testimony, and unexplained delay in legal proceedings.
Here, my lord,
and contradictions between different accounts and events.
No, even they have the decisions are on the light. Even some explanation has been given by the witness for his belated disclosure. But if that explanation does not appear to reasonable to the court, then the court also may discard it. It's not that some explanation has been given. So explanation is also to be analyzed by the court, whether that explanation is a plausible explanation or not. So that light it is there. So.
I have also prepared a note. Complete
No, we are not closing it. We'll close it on Tuesday. So you have prepared the note. You have not prepared actually. You have given some citation.
28 तारीख
आपको गौड़ान
रहिबिनी
28 तारीख
रहिबिनी
ना ये पाठड़ ही गला ना
तापर 30
डेट आज सेकंड डेट है
30 तारीख दिन ମୁଁ ରହିବିନି ଦିନ କୋଦଳା
लिस्ट रो हमें बाहर करूँ मैं सेमती लिस्ट रही तो यदि हमको डिफिकल्टी हुए ताले
I would say
30 तारीख दिन बट यू प्रिपेयर योरसेल्फ यही आउ विशेष ये ना एक दिन सोड़ा का कौन ये कौन but some contradictions are there. You
Yes,
cannot with
ma'am.
reference to that Madhav alias Sachidan, and it's a vital contradiction.
yes, ma'am.
Participation, man, direct assault, we have seen that even proof each model. I have through the direct.
I am not disputing that. Assault to Madhav, I am not disputing.
ये
I have also examined.
सोड टाणी आइला ताटू आणि की निजे केतोडा को ब्लो देला एटा नाही ना
161 ना तू
ना 164 but the presence etc that is there. What you
The implication is only 34 or some overtake by stopping them.
calling and calling the witness. That means they have a intention to kill.
Yes.
And it was a pre-planned because when the other accused person they come with a sword. Therefore, they have a planning to commit murder of the deceased.
They were going to a particular place, Jatra, towards the Jatra. ଆଉ ତା ଛଡା ତାଙ୍କର ଗୋଟେ କଣ କାମ ଥିଲା ପରା
ଯାତ୍ରାକୁ ଗଲା ବେଳକୁ ଗୋଟେ ଟ୍ରକର ଡ୍ରାଇଭରକୁ ଡାକିବାର ଥିଲା
ସେ କାମଟା ଓଭର ହେଇଯାଇଥିଲା
ସେଟାକୁ ଅନ୍ୟ ଦି ଜଣ ଗୋଟେ PW4 ଗଲା ଡାକିବା ପାଇଁ
Madhav stopped and detained two persons, allowing one to.
deceased and PW8
right.
ହଁ କାର ଗୋଟେ କଣ ଫ୍ରାକ୍ଚର ହେଇଯାଇଥିଲା ନା
ମାନେ deceased ର ବଡ
So PW8 and deceased were stopped, and PW4 was asked to go and arrest the driver.
When he
returned.
Again, Madhav went to the road, called PW4
right.
to the place of offense. Here, my lord, there was a pre-planning to commit murder because
ଯେ ପର୍ଯ୍ୟନ୍ତ PW
for no assault ହେଇ ନଥିଲା
ଗୋଟିଏ assault ହେଇଥିଲା
ଗୋଟିଏ assault ହେଇଥିଲା ବସେଇଥିଲେ
ସୋଡ assault
ନା ସୋଲ୍ଡ assault ହେଇନଥିଲା
ତାଙ୍କୁ ବସେଇଥିଲେ କାଲି
yes
PW4 ଆସିଲା ପରେ ହିଁ ଜାଣ ଏଇ ଯୋଉ ସୋଡ assault ହେଇଛି so we're keeping it on having part of ଆଜି ଏଇଟା ଦେଲେ ବୋଲି ଖାଲି ଦେବେ the Learning Council for the Learning Amicus Curiae placed some submitted memo citation so which is taken on that one. Our further argument place this matter on 28th of October.